Hi, my name is Carolina Vargas. Today I will talk about this article, Causation and Responsibility, the Compensation Principle from Groutis to Calabresi. Comparative causality. The positive economic model that allows evaluation the advantage of this principle and in turn the limits with respect to the incentives to adopt levels of attention and efficient activities for both the perpetrators and the victims. Third law. The current non-contractual liability system distributes liability based on fault. Calabresi proposed a system of responsibility without fault that evaluates cost of the accident in the activities according to the activities and dividing the cost of an accident between the sub-activities. Legal and economist analysis. Calabresi evaluates 5 reforms for the distribution of responsibility. 1. A form of social security general that compensates the victims of the accidents or generates tax revenue. 2. One motorist insurance plans that require each owner to protect themselves against accidents. 3. A program of warrant of benefits. 4. Judicial extension of the law of liability for defective products. 5. Increased emphasis on comprehensive section to prevent action. Civil liability law. There might be situations where neither parties was negligent, but each party could have done something to prevent the loss and did not. We might want to slip the loss. The adoption of comparative negligence and the abolition of the doctrine of assumption of risks. It could have the tendency towards comparative caution. Instead of determining who is at fault, the court's goal assigns liability to each party to the extent that each party was the cause of the accident. Modern application of the principle of causation. There might be situations where neither party was negligent, but each party could have done something to prevent the loss and did not. We might want to split the loss. The adoption of comparative negligence and the abolition of the doctrine of assumption or risk. It could have the trend towards comparative causation. Instead of determining who is at fault, the courts hold assign liability to each party to the extent that each party was the cause of accident. Strict liability and negligent conduct. He contrasts between strict liability and the modern notion of negligence is not relative to fault but to judicial balance. Rules. The similarity of purpose between the rules of comparative negligence and those of comparative causation, in the sense that both seek to achieve an equitable method of assuming responsibility for an injury or loss. Findings. Whenever it is desirable to apportion the loss between the parties so that the injured and the victim can truly expect to share the loss, comparative causation may be a better legal instrument than comparative or contributory negligence. Thank you so much.